Police officer looked into apartment window and through a small gap in the closed blinds, he observed two individuals packaging white powder into small baggies. Now that powder the officer believed was cocaine. With those observations in hand, he obtained a warrant to search the entire apartment, and inside he found some incriminating evidence. Now the two individuals that were later charged with drug possession and distribution argued that the initial observation by the police was in violation of their Fourth Amendment rights. Remember, the Fourth Amendment protects you against unreasonable searches and seizures, and the initial observation by the police was done without a warrant. And warrantless searches and seizures are per se unreasonable under the Fourth Amendment. Now, when we're talking about the Fourth Amendment, we know that your home is protected. It is explicitly listed in the Fourth Amendment and perhaps gets the most protection. But when we say your home, whose home is it? Well, in this case, the two individuals did not live in that apartment. We know that the residents of the apartment would get the protection. There are cases out there, and the Supreme Court has previously said that overnight guests get protection under the Fourth Amendment. But what about people that are there for a few hours conducting what we can call business? That is the question today. And before we go on, I want to thank you for watching me here on YouTube. Welcome to Lost Ash channel. If you're new to this channel, give it a thumbs up, subscribe to it. If you're a returning viewer, you know what to do. Share it with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lostash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Lost Ash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Ash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Ash YouTube page. That's LAWSTACHE.
Today we're discussing a Supreme Court case, Minnesota versus Carter and Johns. Both Carter and Johns lived in Chicago, Illinois. They traveled to Minnesota and they went to an apartment of a woman they've never met before. But the agreement was that all three of them would be packaging cocaine into small baggies, and the woman allowed them to use her apartment in exchange of receiving 1/8 of an ounce of cocaine. Now they were there for about 2.5 hours packaging cocaine, and in the meantime, acting on a tip, a police officer came up to a window and through a small gap in the blinds observed all of them packaging cocaine. With that information, the police obtained a warrant to search the apartment. Sometime later, when the two men exited the apartment, they drove off and were arrested. During the search of the vehicle, some narcotics were found. And based on the warrant, the officers executed the warrant of the apartment, and inside they found some more incriminating evidence. Now, both men were charged in Minnesota with state charges based on the findings of cocaine. It was the distribution and possession and so on. But Carter and Johns argued that the initial observation by the police violated their Fourth Amendment rights against unreasonable searches and seizures. Remember, when the officer was observing the packaging through the window, at that point, he did not have a warrant yet. So both Carter and Johns say that was unreasonable under the Fourth Amendment. And since we're discussing the Fourth Amendment, it is important for us to look at the text and understand what it means. So let's do that now. The Fourth Amendment guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The amendment protects persons against unreasonable searches of their persons and houses, and thus indicates that the Fourth Amendment is a personal right that must be invoked by an individual. Based on the text, we know that the Fourth Amendment protects people, not places. But the next question becomes, who are these people? Now, courts have previously articulated that it is individuals who can show that they had a reasonable expectation of privacy in the place that was invaded by the police. We know that the resident or the owner of the home would enjoy the most protection. Courts have previously also said that overnight guests would get a similar protection. The Supreme Court in Minnesota versus Olson decided that an overnight guest in a house had the sort of expectation of privacy that the Fourth Amendment protects. They said to hold an overnight guest has a legitimate expectation of privacy in his host's home merely recognizes the everyday expectations of privacy that we all share. Staying overnight in another's home is a long-standing social custom that serves functions recognized as valuable by society. We stay in others' homes when we travel to a strange city for business or pleasure, when we visit our parents, children, or more distant relatives out of town, when we are in between jobs or homes, or when we house sit for a friend. From the overnight guest's perspective, he seeks shelter in another's home precisely because it provides him with privacy, a place where he and his possessions will not be disturbed by anyone but his host and those his host allow inside. We're at our most vulnerable when we're asleep because we cannot monitor our own safety or the security of our belongings. It is for this reason that although we may spend all day in public places, when we cannot sleep in our own home, we seek out another private place to sleep, whether it is a hotel room or the home of a friend. The Supreme Court says that in this case, Johns and Carter did not live in this apartment and they were clearly not overnight guests. Instead, they were there for only a short period of time. There was no connection between them and the woman that allowed them to package the drugs inside her apartment, and they were there strictly for commercial purpose. The court calls this individual a short-term business guest. And to understand it a little bit better, let's hear it as summarized by Justice Rehnquist in his delivery of the opinion of the court.
We now address that question and conclude that Carter and John's Fourth Amendment rights were not violated. The Fourth Amendment protects people against unreasonable searches of their houses. We held in Rehnquist that the defendants in that case could not claim the protection of the Fourth Amendment over weapons seized from someone else's car. And we held in Minnesota versus Olson that an overnight house guest could claim the Fourth Amendment protection over the house in which he was staying. This case involving short-term business visitors obviously falls somewhere in between. Here, Carter and Johns were not overnight social guests. They had no prior relationship with the owner of the apartment. There was no other purpose to their visit but the business purpose of packaging drugs. And we have held that the Fourth Amendment does not protect as rigorously in the commercial context. We therefore hold that Carter and Johns, as short-term business guests, could not claim the protection of the Fourth Amendment in the apartment.
Well, I hope you now understand the differences between an owner or resident of the home versus an overnight guest or a short-term business guest like we had in this case. All of the different individuals would enjoy different protections under the Fourth Amendment because they have different reasonable expectation of privacy in the place they're staying. Now, of course, these are reasonable expectation of privacy in a house, but we've previously discussed a similar concept when it comes to cars. We've talked about drivers, passengers, people who rent a vehicle from a rental company, and even people who borrow that vehicle from an individual who previously rented the vehicle. All of these are different variations of the Fourth Amendment when it comes to vehicles. And it is perhaps a good time now, after this video, for you to check out the videos that relate to vehicles. Or go back and look at more of my videos that discuss homes. In any event, thank you so much for watching me here on YouTube. If you're new to this channel, hit that subscribe button. If you're a returning viewer, thank you so much for returning week after week and sharing my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. I will see you next Wednesday for another deep dive on another criminal case. Thanks for watching.